Hello, I'm Rebecca Thornley-Gibson, employment partner at DMH Stallard, and I'm joined by Rustam Tata, head of the employment team at DMH. And welcome to our employment law podcast, Conflicts with Protected Characteristics. So today, Rustam and I are going to discuss some of the issues that employers are now facing in situations where there's a conflict between protected beliefs held by employees. And this is an area that's creating a substantial amount of employee relations issues and also generating a good amount of case law. The sensitivities surrounding many of the reported employment tribunal cases have led to mainstream news headlines, and perhaps this is one of the reasons that employees themselves are now becoming much more aware of their right to voice their views and the potential limitations on their employers to perhaps limit those discussions and moderate behaviours. So I think, Rustam and I, as employment law practitioners, have seen that where employees have caused offence to others, you often deal with that by disciplinary action. But since the Equality Act introduced religion or belief as a protected characteristic way back in 2003, employers had to be mindful that that disciplinary action or other treatment doesn't amount to discrimination on the basis of that individual holding that protected belief. Since 2003, or perhaps, the sort of years immediately preceding 2003, what we found is that most cases on belief tended to focus on the religion element, as the definition of belief wasn't that clear. And so perhaps before we get into some of the cases that we'll be talking about, it's perhaps helpful just to remind ourselves of what the test for a protected belief is. And that comes from the case of Granger in 2010. So to be a belief, it can't just be a whim. It can't be somebody turning up one day and saying, well, I believe in the solar system. It's got to be a belief that's genuinely held. It's not just got to be an opinion based on sort of current information available. It's got to be a weighty belief and impact a substantial aspect of human life and behaviour. It's got to have a certain level of truth with it, seriousness and importance. And the last limb, which is the one that tends to be tested, is that it's got to be worthy of respect in a democratic society and shouldn't be incompatible with human dignity and not conflict with the rights of others. So following Granger, a lot of beliefs were tested in the courts, and a lot failed the test that they were worthy of respect in a democratic society. There were some very unusual beliefs that the tribunal had to determine, and some beliefs which perhaps people thought wouldn't pass the test, but did. So a couple of those to throw out. So we've got ethical veganism, we've got climate change. What we saw, however, in 2020, following the case of fore and CGD Europe, which was essentially a case about gender critical beliefs, is a much more robust response from the tribunal as to what is and isn't considered a belief, and therefore what is capable of protection from discrimination. So the courts actually determined in the fore case that the belief might be shocking and offensive, but that isn't enough to remove it from being a belief capable of protection. What they actually said was that only beliefs akin to Nazism and totalitarianism, or those supporting violence and hatred, would fail the test of being worthy of respect. So that was a massive widening, I think, of the Granger test, and perhaps gave the green light for some, for employees generally who've perhaps been cautious about sharing beliefs at work, to feel much more able to do so. And perhaps they felt even more able to do so once Miss For Starter was awarded £100,000 for her particular discrimination claim arising from the non-renewal of her fellowship because she had made fairly vocal remarks on social media about gender identity issues. So I think before for starter, we'd had a lot of situations where we accepted that there were fundamental sort of opposing rights that individuals might have. We had back in 2018, which was to some perhaps the infamous Lee and Ashes case, which some people had referred to as the gay cake case. So as a reminder there, Gareth Lee, who was a gay man, requested a cake to be baked by Ashes bakers with the slogan "Support Gay Marriage" on the top of it. Ashes refused. They said that their Christian beliefs were directly opposing the beliefs of Mr. Lee, and they were against same-sex marriage. Mr. Lee took his claim all the way to the Supreme Court, who determined that there'd been no actual discrimination on sexual orientation grounds towards the claimant because the refusal by Ashes was not on the basis of the individual sexual orientation, but was actually on the basis of the message that Ashes had been asked to write. And the bakers should not have had their right to freedom of expression and religion curtailed. And there was no unlawful discrimination in that particular case. But I think since the Forstater case, we have seen a growth in the number of cases being litigated. And perhaps if I turn to Rustum, who can perhaps just give us a flavour of some of the more recent cases which are demonstrating this employee tension.
Absolutely. Thanks, Rebecca. And in a sense, Lee and Ashes and Forstater don't necessarily sit that well together either. But looking at some of the more recent and relatively public cases, we've had the Higgs and Farmers School case, and that was a case involving the employee who'd been dismissed from her employment at a school for posts that she'd made on her Facebook profile. One post opposed the teaching that gender is fluid and not binary, and the other post contended that same-sex marriage cannot be equated with traditional marriage between a man and a woman. Neither post was directed specifically towards anybody. A complaint was made by a parent at the school that the posts contained homophobic and prejudiced views, and following an internal review, Ms. Higgs was suspended and ultimately dismissed. So here you had a situation essentially where the school was concerned about perception of parents and others. You had Ms. Higgs saying, well, these are my genuinely held views and I'm not expressing them in a particularly aggressive or intimidatory way. And that's a point that I'm sure we'll come back to later on. So in this case, the Court of Appeal determined that Ms. Higgs had not expressed her view in a way which could be said to be so objectionable or so aggressive that the approach which would have said it was unlawful for her to have done that. But the employer needs to show that it was a proportionate response to the objectionable feature. And in this case, the extent of the objectionable feature was really found to be the fact that a parent and some others objected to it, but the post itself wasn't inherently objectionable. And the school had sought to justify the dismissal on the basis that the posts were intemperately expressed and included insulting references. However, the Court of Appeal said neither the language of the posts nor the risk of reputational damage in this case, and it's really important to highlight that in this case, these are fact-specific cases, that neither of those things were capable of justifying the claimant's dismissal. After that one, we move on to the case that's received a lot of media attention earlier this year, and probably rightly so, and a lot of head-scratching, I have to say, by quite a few lawyers on this. And this is the For Women Scotland case. Well, it's referred to as the For Women Scotland case, actually the second case because there was an earlier case involving essentially the same parties. But in this case, what happened essentially was that the Scottish ministers issued some statutory guidance, essentially guiding as to whether or not an individual who was in receipt of a gender recognition certificate would be considered to be, in this particular case, a woman or not, under the terms of the Equality Act 2010. And essentially what the Supreme Court said in this case was that you look at the definition of man and woman by reference to biological sex. So biological sex has been contrasted with what's very often termed certificated sex. So biological sex meant that in this instance, an individual with a gender recognition certificate would not be covered by the Equality Act. And as I say, that has led to quite a lot of head scratching and difficulty. And the Supreme Court said, rightly or wrongly, that as a matter of ordinary language, the provisions relating to sex discrimination can only be interpreted as referring to biological sex, and they drew very heavily on the provisions protecting women in the context of pregnancy and maternity rights, and sought to use that essentially as the bedrock and as the basis for saying, well, a biological man cannot become pregnant, so cannot be considered essentially in any circumstances to be a woman. And again, they looked back to the Sex Discrimination Act of 1975 and said, well, essentially the same approach was being taken in 2010 by Parliament as in 1975. And of course, that probably ignores the fact that since 1975, the whole issue of transgender individuals, the whole issue of gender fluidity and the arguments around that have obviously very much come to the fore, whereas they weren't really discussed in the mainstream in the 1970s. And the other thing that the Supreme Court said is that it was critically important that the Equality Act was read, terms in the Equality Act were read consistently, so that when you looked at one provision and considered a definition of a man and woman, they would be the same. So I just sort of pause there, and I don't know, Rebecca, whether you have any views on the For Women in Scotland case, whether it's a helpful or an unhelpful case, or whether it gives employers more headaches or clarity.
I would say initially it certainly gave them more headaches because a lot of the initial advice that was put out by the EHRC was quite knee-jerk, and it focused quite heavily on the whole sort of same-sex facilities argument. So we were having clients writing to us saying, well, what on earth are we doing with our, toilet facilities, for example? And I think within a few weeks of the decision coming out, there had been 2 or 3 iterations by the EHRC of quite what the correct thing to do was. So it wasn't helpful for that. I think it was unhelpful as well because it was just such a complicated judgment for employers to get their heads around. It was also a Scottish case, but obviously highly persuasive. There seems to have been, for whatever reason, quite a lot of cases in Scotland against be it hospitals or sort of government authorities. I was looking at the news this morning, and there was a fairly long-running case that had been brought by Sandy Peggy against NHS Fife, and that was also around a female changing room. So Sandy Peggy was a nurse, or is a nurse rather, and she'd had an exchange with a trans doctor that was using the female changing room at the hospital. Now, I talk about this case not so much from the law, but from the impact of an employer perhaps having to deal with a case like this. So the case started in December 23 when Sandy Peggy had her exchange with Dr. Beth Upton in a female changing room. There was then a complaint by Dr. Upton about Sandy Peggy's behaviour. There was a disciplinary action, disciplinary investigation. And then Sandy Peggy in May 24 launched a tribunal claim against NHS 5 and also Dr. Upton for harassment, belief discrimination and victimisation. There was then a bid to have the matter dealt with in private by NHS 5 and Dr. Upton because they realised the sensitivities that a case like this perhaps brought. That was rejected, and then there was a 10-day tribunal in February 25. There was then in July 25 a press release by NHS 5 basically saying how much money that the taxpayer had to foot because of Sandy Peggy's claim. And that inherently suggested that they were a bit cross with Sandy Peggy. And Sandy Peggy saw this and brought a victimisation claim. By way of comment, the NHS 5 cost as at, I think, July 25 was just over £250,000. But just on financial impact, you can see a case like this is significant. And I think NHS 5 were making the point on the basis of, well, how many hospital beds we perhaps had to lose because we've had to fight this tribunal case, which probably wasn't the best thing that they could have done. Anyway, there have been more claims now that have been lodged by Miss Peggy in respect of other comments made by staff and senior leadership team at NHS 5. And it's one of those cases that's just going to run and run. And the legal argument's probably going to get lost in some respect because the parties are just now embattled because of the tensions. Could NHS 5 have done anything differently? Perhaps not have gone straight into a disciplinary investigation, or perhaps have laid out some policies and procedures and boundaries and expectations, and been more supportive in respect of the views of all its staff, rather than perhaps launching, as they did, into the disciplinary. So sort of that's my take on perhaps the impacts that certain of these very high profile cases can have. And you talked about Higgs before. I think a lot of these cases involve employees who are posting on social media, on their personal accounts particularly, and then what is picked up by employers or other employees in respect of those views. So it's not always direct workplace communications that employers have to police. It's often looking at personal views on personal posts. But I think whatever there is, employers are picking their way through a real minefield of conflicting views. A couple of other interesting cases as well, not necessarily reaching sort of the public domain, but case of a gentleman scientist called Peter Wilkins, and vocalised his gender critical beliefs. And as a result of that, employees referred to him as sad and pathetic, transphobic, and a rubbish employee. So he resigned, brought a constructive dismissal claim and a discrimination claim. And what the tribunal found here is that senior staff within the organisation had not intervened to stop the harassment. It was quite clear that he was getting a really, sort of rough ride. And what HR should have done is been more vigilant in recognising the tensions that were created by staff holding different views to each other. And they should have sought to create a workplace that was far more supportive for everyone, set out boundaries and expectations of behaviour, and also set out a culture where tolerance of views is something that employees need to consider. Not easy at all, but that is, the consequences of not supporting an employee who is being harassed in those circumstances is quite significant. We've got a really interesting case at the moment. I don't think it's going to be successful in respect of the employees who have brought it. But it concerns 3 union officials who brought a claim against Unite Union, not on gender critical beliefs, but on the basis that they are saying that they were discriminated against by having moderate left-wing socialist beliefs. Now, in the UK, we don't have political beliefs as a specific protected discrimination. So what a tribunal is going to have to do is rule on whether moderate left-wing socialism can actually amount to a belief under the religion and belief protected characteristic of the Equality Act, and whether those 3 union officers were harassed and subjected to detriment because of their political views on moderate left-wing socialism. The tribunal judge, or the employment judge, was already at a preliminary hearing made a remark that he probably doesn't think that this is going to be successful, but it's going to be a very interesting analysis of, again, what amounts to a belief. And I think it's just chipping away at people's views as to whether, they can amount to a belief. So I'd watch the space on that Unite the Union case. So a couple of other cases before I pass back to Rustum. In the Fahy and the Arts Council, there was a situation where there was public support for a particular protected characteristic by the deputy CEO of that organisation. So he expressed his views in a work meeting that a particular organisation was divisive, had a history of anti-trans exclusionary activity, and the deputy CEO emailed staff indicating his personal solidarity with trans and non-binary colleagues. However, that had unintentional consequences, as another employee then emailed all staff referring to a grievance raised by the LGBTQIA+ working group, which related to homophobia and anti-trans views of other senior staff in the organisation. And that employee then had a link to a petition on which other employees of the organisation put their comments, referring to gender critical views as being anti-trans, bigoted and transphobic. Now, the tribunal found here that whilst the deputy CEO comments about various gender critical beliefs were not harassment, it had actually been inappropriate for him to express his personal opinions, and his actions had led to the harassment of other employees, one employee in particular who held gender critical beliefs. So the deputy CEO was presumably trying to be supportive of one of protected characteristics, but that led to that group becoming the subject of harassment. And I think here it's a case of query, at what level in the organisation do people perhaps have to accept that their personal views probably shouldn't be shared? And I think it is controversial because, if we're trying to be inclusive to everybody, should we be inclusive to everyone, irrespective of their seniority? But I think if you have someone in a position of significant influence, perhaps part of the senior leadership team, their comments are going to have more weight, I think, and more power than perhaps other employees. And that is something that I think employers should take into account when they're putting forward their policies, writing, sort of giving their training, and just generally setting the culture of the organisation. Now, Eve, what your views on that, Rustum, might be in terms of, is it one rule for, one group of employees based on seniority and, one rule for others?
It's a really tricky one, Rebecca. I agree. I mean, in that Arts Council case that you were referring to, I think it was unfortunate that whilst the comments were clearly qualified by the Deputy Chief Executive, because they weren't based necessarily on fact and substance, it was not hard to argue that they could potentially be viewed as being bigoted or based on stereotypes or whatever else. I guess that certainly the seniority is one take. I guess my take might be slightly different. And I just wonder whether we've reached the point where talking in terms of zero tolerance, as we do for certain situations, and so we have zero tolerance for, well, historically maybe racism, or zero tolerance for sexism, or zero tolerance for views that are against individuals who hold a particular protected characteristic. Whether that's actually realistic, if at the same time we're saying that everybody should be able to express their views. Now, there's always that difficult line, and you referred to it earlier in the context of the Granger case, Rebecca. There's that really difficult line that looks and says, well, actually, is the view worthy of respect in a democratic society? And they talk about Nazism as being the extreme, and that wouldn't be worthy of respect because it's anti-democratic. But there's that second limb that I'm struggling with, and it's also supposed to be compatible with human dignity. And anything that is extreme, and if you like, seeks to block out or completely deny airspace to anybody else because their view might be uncomfortable or difficult or might even offend, is that just creating another injustice somewhere else? So that's my take on it. I mean, it's very much, I wouldn't say fashionable, that sounds a bit too harsh, but where we're looking maybe at anti-harassment, particularly in the context at the moment of the recent regulations around sexual harassment in the workplace, but it's not solely relating to that. We talk about zero tolerance, and of course employers are told, well, you need to have a clear zero tolerance policy. You need to tell your employees you've got a zero tolerance policy. That suggests actually a hierarchy of protected characteristics. And that's another debate, which, to be honest, I think is really interesting, about whether there should be more of a hierarchy. But the case law in the UK has very much said there is not. There is no hierarchy of protected characteristics. There was a time where I thought maybe religion and belief, or certainly belief, might be said not to have perhaps the same weight as someone's biological gender or their race or something else, which, if you like, they are, in inverted commas, completely born with, rather than a belief which is obviously fostered and developed over a period of time. But that isn't where our law is. So I don't know, Rebecca, what you think about this. Do you think we might revert to a right to offend? And what might the limits of that be?
Yeah, I mean, just going back on the zero tolerance policies, what is the zero tolerance policy? A zero tolerance of what? Zero tolerance of poor behaviour? Well, that's addressed elsewhere in disciplinary policies and general codes of conduct. So I think this sort of whole approach to zero tolerance policies I think it is unworkable. And I think that, it's less relatable to the protected characteristic and more relatable to the conduct that an employer is entitled to take action against. If somebody is having a debate about their different views, that's okay. If somebody's having a debate about their different views and it then becomes heated and they start swearing and somebody feels threatened, then that's a completely different issue. It's not zero tolerance about talking about the different views. It's a zero tolerance really about it comes down to the way in which, not just the manifestation of those views, but the way in which those views are being exchanged, particularly in the workplace. I think Lloyd's Bank were probably feeling pretty sore after they had been subject to a £500,000 compensation award against one of their employees who attended a training session and used what Lloyd's considered was unacceptable language, which is unacceptable language. They used the M word in respect of asking a question as to whether that word was a slur acceptable use in certain circumstances? And even though it was a question in a training session where delegates had been told something probably along the lines of no question is a silly question, we're open and transparent, you can ask anything. Well, clearly they couldn't ask anything because this employee was dismissed for breach of the bank's zero tolerance anti-discrimination policy by using that word. So context is everything as well. And when context is everything, it's very difficult to then apply a zero tolerance policy. So I think that's my take on that. And coming back to the right to offend, we're all going to be offended at some point because we will have different views, and we're all subjective in those views. So perhaps it is a right to offend. Perhaps that's what it is. But my take is probably that as these cases start to develop, employees themselves are perhaps going to be more aware that they might be brought in as respondents, they might be disciplined, they might, suffer some, sort of detrimental sort of action because they have manifested their views. And I think we're probably going to go to a silent culture in terms of non-work related conversations. And that's quite a shame, really, because then we just become quite robotic in our workplace interactions. And I think that is bad overall for culture. So that's the unintended consequence of some of these zero tolerance policies.
It's really interesting, isn't it? Also, how these things go as a cycle. I mean, for quite a few years, it was all about bring your whole self to work. And that's part of this, where one person will say, well, I'm being entirely genuine. But the person sat next to them will say, so am I. I'm reflecting what I think and what I believe. I absolutely take your point, and but it is, I'd say, the head of a pin that a lot of the cases turn on as to how it manifests itself and where the line is between expressing a view firmly and then, as it were, crossing that line. I mean, I don't think we touched on it, but the McBride case, another case in Scotland involving a temporary worker essentially working as a civil servant. In that case, when you read that very long judgment, it's fairly clear that the tribunal came to the view that it essentially Mr. McBride found that he'd been persisting in harassing other civil servants over his views, and he would contact them privately online following online discussions around gender issues. And those other colleagues found that his approach is distressing, intimidating, and even unsafe. So you'll get those more extreme cases. I guess, again, it's another example for me of the law trying to force social change for good or ill, but through the employment relationship in terms of how people behave. So I guess back to you, Rebecca, but I guess it's a real watch this space area.
It is. It's a watch this space because there are lots more cases coming through. It's HR knows the difficulties in this area, and HR are getting to a stage of perhaps feeling, how on earth do they police all of these conversations? How do they, stop certain conversations, communications? When people have their human rights, rights to express their opinions. But I think it is it's such a challenging area for employers and HR particularly. And I think all they can currently do is make it clear that there are certain values and expectations that their organisation has, and that conduct that is, that is offensive, is conduct that there is likely to be some investigatory action into. So yes, we've got lots of high profile cases, we've got lots of, protected belief issues around. But at the end of the day, employers want people to work in an environment that is one where people respect each other, It is one where people can come to work and feel, sort of psychologically safe in their workplace. And it's perhaps a more humane position for HR to take, to set out that they are supportive of all views, but those views really do need to be, exchanged in a way that is respectful of others. And, action may be taken, not will be taken, but may be taken, in circumstances where it is found that people have become, upset. People can still bring grievances, and I think that's what's going to happen. There's going to be an awful lot of grievances on the back of this. Not all of those will result in disciplinary action, but employers, HR will still have to deal with the grievances that are brought because people feel as though, they've been put in a difficult situation. Thank you very much for listening, everyone. I hope you've enjoyed the debate. The discussion is going to continue, of course. You can find this podcast and all our other DMH podcasts on Spotify, Apple Music, and wherever else you get your podcasts. Thank you for listening.